Hi, and thanks to the organizers for this great conference. I'm happy to be here. My talk today will include uh, three parts. The first one, I'll introduce my research and present what Israeli anti-occupation human rights NGOs are, and I'll explain the concept of what I mean by achieving human rights failure. I'll then present my two main research fields and show how the topic of democratizing human rights relates to NGO archives. And I'll end with some basic or preliminary insights around these themes. So first of all, my research is about Israeli anti-occupation NGOs, which can be defined based on both their histories and what they do. So in terms of their ongoing histories, we're talking about currently there are around 12 to 17 active NGOs that their main focus is on Israel's occupation of Palestinian territories and the human rights abuses that Israel's violence against Palestinians. These NGOs are either completely focused, that's the only thing that they work on or their mandate, or the occupation is one of the main focuses of the NGOs. The first such NGOs were founded in the late 1980s after the eruption of the first Intifada, or the Palestinian resistance to Israel's occupation. And then in the early 2000s, with the second Intifada, there was another wave of new NGOs. But currently, as I mentioned, I would say that there are about 12 to 17 such active NGOs. Some were active and have already folded and closed. And the NGOs really vary in terms of what they do and or mainly in how they do it and how many people work there. So the largest NGOs have there are a couple of NGOs that have around 50 employees tops. But there are a couple of, at least two NGOs that have maybe two or three regular employees. And the other main theme or what makes this an actual field that is anti-occupation NGOs is some of the characteristics that they share. So what makes them Israeli, for example, is that they are based in Israel 1948 territories, that their offices are there. Why do we even call them non-governmental organizations or NGOs is because they're not activists. They are professional organizations. They need to register with the state and have some sort of bureaucratic and financial structure that makes them NGOs and differentiates them from activists or other groups. Again, anti-occupation is what I would call all the NGOs that focus on Israel's occupation. And human rights, not all of the NGOs that are anti-occupation do this through human rights. So, for example, you have an NGO like Breaking the Silence that documents soldiers' testimonies, and they refer to human rights, but what they do doesn't rely on human rights advocacy and the professional structures that are known, I would say, globally as what human rights work is. And the last and most relevant theme for this talk is that these NGOs have archives. For some of these NGOs, as I'll show, the archives are more publicly accessible. Others don't really have a public archive, but each organization inherently has to have some type of archive that includes both materials of human rights and materials that are part of the office work and bureaucracy. Now, it seems obvious maybe at the end of 2025 to say that human rights fail in Israel-Palestine with the tragedy of October 7th and the genocide and war that followed. But Israeli NGOs failed long before October 7th. And that failure can be seen in different ways. So one way in which we can see their failure is that the NGOs themselves declare on their websites that their aim is to bring the occupation to an end, which of course it hasn't ended yet. So here are a couple of examples of prominent NGOs who declare that on the website. We view the occupation as the main source of the violation of human rights and therefore seek to end it. And B'Tselem, probably the most prominent NGO, such a future, like a future of a more just future, such a future will only be possible when the Israeli occupation and apartheid regime end. So that's one way to frame failure, but the failure is much more thorough and dominant in the everyday work of NGOs. I witnessed this sense of failure and what it does when I did almost 3 years of participant observation research in 4 different NGOs for my dissertation project. And the NGO staff themselves say that human rights fail. So it's like an everyday experience and not just like a meta failure. B'Tselem, again, probably the most prominent NGO, itself in 2016 acknowledged its own failure and decided to stop co cooperating or communicating directly with the Israeli state and its various extensions as part of its understanding that what the NGO has done doesn't work. But there are other critiques from outside of the NGOs, like academic critiques and activist critiques about how the Human Rights Project is failing. Now, it's important to say that even though I say it's failing, it doesn't mean it doesn't have any significance and it's not important and what the NGOs do isn't worthwhile. And that's why I'm talking about achieving failure. So this comes from a Anthropology of Education article by McDermott from 74, Achieving School Failure, in which he talks about how students, children who fail at school, oftentimes put in a lot of work to fail. So it's not failure doesn't just happen, it's something that is achieved and is done. So when we talk about achieving human rights failure, what I mean is that it's not just that the NGOs fail because reality is terrible or because human rights advocacy is ill-equipped to deal with reality. It's because there's a system with certain practices that design this failure and re-perpetuate it every day for the NGOs. Part of that is to tire them and to stop them from reaching any substantial change. And the question is, how come the NGOs don't adapt to contend with that failure? What does the system of human rights itself do to alter its course? And maybe it doesn't do enough, but again, that doesn't mean that we can't learn from this failure and understand how it is still productive, creative, and important, and what we can do differently. So the archives aspect is specifically interesting in relation also to the conference theme, because at least in Israeli anti-occupation NGOs, the archival function relates to how the NGOs can do things differently or not differently, both in relation to the global human rights standard and in relation to violence in Israel-Palestine. So for Israeli NGOs, for my dissertation research, I looked at the bureaucracy of witness testimony collection. And Israeli NGOs since the 1980s rely on Palestinians' witness testimonies. And when the Israeli NGOs, they send a Palestinian field worker that works in the NGO to collect a testimony of a Palestinian who has witnessed, whether as a bystander or themselves as a victim, a human rights violation of any category, anything from torture, settler violence, house demolitions, and more extreme cases, even more extreme cases. And then when the NGO collects the testimony via the field worker, the Palestinian witness needs to sign a power of attorney document. And that was what I would call an extraction point, where the Palestinian's witness testimony is taken away from the Palestinian witness and is now in the authority of the NGO. And the Palestinian witnesses can mark what they want the NGO to do with the materials that they give them. So they can publish it in media anonymously or not. They can appeal to the state, and they can use it for research or not. So the witnesses can control if the NGO will just collect the testimony or use it somehow. But essentially, that's where the rights to the case are given to the NGO that would still ask, they would still be considerate of what the Palestinian witness wants the NGO to do or not, but it is in the hands of the NGO from that point on. And the other aspect of where NGOs, Israeli NGOs, kind of control Palestinian documentation is that through from the mid to late 1980s and from the early 2000s, several NGOs have amassed a huge amount of documents, and they have really significant archives that are quite unique in their documentation of Israel's violence and of Palestinian lives and deaths in the shadow of this violence and occupation. And the NGOs, for the most part, that's what they have, the archives, and I don't know of any project that suggests realigning the custodianship of these archives and give them back to Palestinians or use them differently. There are some projects to put archives in academic institutional hands to protect them and maybe make more use of them. But generally, the NGOs, again, other than controlling the witness testimony documents, they also control the archives that hold them. And it's not just the testimony documents. There are a lot of other documents that are also there and are part of the files for each case that an NGO handles. So there are medical files, photos, and other types of documents. And the NGOs essentially have three, each, not all NGOs, but like the more prominent ones have like three types of archives. One is a public archive that is usually on an NGO's website. So the research reports and other routine data that they publish and statistics and news, etc. And then there's the actual human rights archive. So all the work that the NGO does, usually it's a physical archive, but there's also like digital computerized archives. And that archive is usually not publicly accessible, which again puts the authority in the hands of the NGO and not back to Palestinian communities. But some researchers, artists, journalists can ask for access to parts of the archives. I don't think there's a possibility to get access to the whole archive. And the whole archive is like what archivists, what archival sciences would call the actual archive is the NGO, like the entire NGO materials that are not just the human rights materials, but also the bureaucratic and office materials. So that's one research that I did, in which archives are prominent, the bureaucracy of witness testimonies. The other project is about how artists use NGO materials. And again, that relies on NGO's archives. So often relies on NGO archives. So artists can either collaborate directly with NGOs to produce different kinds of art, or they can ask the NGOs for access to materials and draw from the archives for their artwork. So this is a few examples. This is Five Broken Cameras. This is a documentary that is based on B'Tselem's camera project. It's less archival, but it does include archival materials. It's more based on collaborating with with NGOs' modes of documentation and activity. Another example is a dance performance by Arkady Zaidas, which is called Archive, and I won't show it now, but you can look it up. It's great, and so what he does is he takes video documentation of settlers and soldiers attacking Palestinians, and he mimics what he shows on the screen through dance. And this does rely directly on archival materials. Sorry, I have a cat here who's meowing. Let me get her in the room just a second. Right? Okay. Um, And this is actually a painting, and it's not. It's if you see, it's from 2004 by two artists, Adika and Shahar Komer. So they went through NGO's photo archive and collected images of house demolitions, created a collage of the photos, and then did this huge painting. You can't see the size of it, of course, here, but it's a very big painting that now resonates differently, of course, when we know the images from the destruction of Gaza. And the more recent example of NGO art collaboration is the Oscar-winning documentary No Other Land, which again is more a direct collaboration with an NGO, but also entails some archival elements. Or this will be the last example. This is really a archives-based art project. It was a performance like a collection of short performances curated together in one evening, where artists took documents from an NGO archive and created different mediums of performance based on those archival documents. So what we see in all of these examples is that, again, like the NGO materials are collected from Palestinians, and then they circulate in different ways that, I mean, I'm not saying that they don't have any significance. Of course, this is important work, and really in the current or recent climates and political reality, socio-political realities in Israel, Palestine, any act of defiance or critique is significant and isn't an obvious, it shouldn't be taken for granted. But the question is, how does the circulation of NGO, of human rights archival materials, what does that circulation do really on the ground, or how does it affect Palestinian communities? What does it do in relation to Israel's violence and colonialism and settler colonialism? And through the art-related project, I think we also see like an extension of what the NGOs do in the sense that the materials don't necessarily relate back to the Palestinian communities, not those that the materials were drawn from, but also not in more general collective terms of Palestinian communities. So the question is really more about democracy is one element, but I think the larger question that also entails a question of democracy is how human rights work can be decolonized, and especially the archiving and archives, which are, oh, cat is jumping here. Sorry. In the sense that controlling and producing certain representations and information and controlling their circulation and accessibility are obviously colonial type modes of engagement, and can they even be decolonized once they're established as those kind of modes of documentation and archiving? And so the question is really not just how NGOs can be more democratic, or Israeli anti-occupation NGOs can be more democratic vis-a-vis Palestinian communities, but how can they be more radically decolonized, so the really important work of documentation and advocacy that they do will maybe offer more than this insightful failure, but actual engagement and changing the course of certain things. I mean, it might sound too optimistic or naive to say that NGOs can bring about massive change, but at least to have a better relation between what Israeli NGOs and anti-occupation work and activism in general does with Palestinian communities in the present. Thank you.
Thank you. Thank you, whoever sorted that out. Technology is always the stressful part of any presentation, so thank you. I was just saying that I'm very sorry I can't be with you. I had really hoped to join you all in person, and I'm afraid I have to just send my greetings from Belfast here in Northern Ireland. But if anyone wants to connect afterwards, please do get in touch. So I'm just going to move ahead since time is of the essence. I'm just trying to see if I can make this bigger. Okay, there we go. So since the 7th of October, there have been growing debates in the media and in academia on whether international law is in fact dead. I'll highlight just a few examples. So 1 month into the war, the headline, "The Rubble of International Law," featured on the front page of this Palestinian newspaper. The Commissioner General of UNRWA declared Gaza is becoming the graveyard of international humanitarian law in an interview with Spanish newspaper El País. This sentiment was echoed by UN experts who stated that the international order is breaking down in Gaza. Some before this pronounced the death of international law, such as Hindi. Others had pointed out that international law was dead decades before the 7th of October. I suppose it would be fair to suggest that international law as a discipline is in crisis, as is the supposed universality of human rights, which is being forsaken in plain sight at the moment. But what do everyday people whose voices are often missing in academic debates and in the media have to say about the state of human rights today? Those most impacted by the wars and selective implementation of international law. So today I want to just share some preliminary findings on some of the diverse attitudes of youth from the occupied Golan and the occupied West Bank, their attitudes towards human rights. But before I do that, I want to just speak a little bit about the Golan Heights, since this is an area that many people know less about. It's a neglected jurisdiction, and then I'll introduce the study before sharing some of the initial findings from the project. So many of you might remember the rocket attack that struck the Druze village of Majd al-Shams last July 2024, killing 12 children and injuring others at the football pitch. So under international law, Majd al-Shams, along with the Golan, is occupied land, and most of the Golani Druze community have rejected Israeli citizenship. This means that they're stateless and their nationality is undefined, which negatively impacts their rights in different spheres of life. Now, due to time constraints, I'll mention just a few key moments when it comes to the occupied Golan, as I think this will help set the scene a little bit. So Israel occupied 2/3 of the Syrian Golan in 1967, and this resulted in the forcible displacement of around 95% of the indigenous population. Today, 4 Druze villages remain. Other villages were razed to the ground, and illegal settlements have been built on this land, and there are plans for this to double by 2027. In 1981, the Syrian Golan was illegally annexed when Israel enacted the Golan Heights Law. The UN issued Security Council Resolution number 497, stating Israel's plans to impose its law and sovereignty over the occupied Golan was null and void. This annexation led to the Great Strike, a key moment in Golani history, where a lot of the community resisted the imposition of Israeli citizenship. Fast forward to 2011, the war in Syria starts, but this had a profound effect on the freedom of movement of those from the Golan, from the Druze villages, both in terms of trade, but also in terms of scholarships and their access to higher education. And then moving to more recently, 2024, following the fall of Assad, Israel has gone on to occupy more Syrian territory, violating the 1974 disengagement agreement with Syria, according to the UN. And then again, something that maybe hasn't appeared in the media that much, certainly not here in the UK and Ireland. July, the Sweden massacre, and there's been an increase in armed attacks on Syrian Druze in Sweden and that area. And this has really shook the Druze community in the Golan. They're related to one another, and it's also left many of them questioning whether there is a place for them in the new Syrian state. So this has led to somewhat of an identity crisis, which I'll talk about in a moment. But the Golan is often referred to as the forgotten occupation, forgotten by the international community that it's even forgotten, that it's even occupied, forgotten by the Syrian regimes, past and present. And now some of the participants in this study told me that even the Golani community themselves are forgetting that they are themselves occupied. Just to sort of summarize this, a young person spoke about his identity being his very existence being political. The biggest human rights issue we face is can you hear me, or is there a problem?
So we can't follow your slides. Can you put this in presentation? Oh. Yeah. Sorry to object.
Sorry.
No worries.
When you shared the PowerPoint file, not the presentation itself.
Oh, okay. I'm so sorry. 1 second. See, I'm using two things as well here. Let's see if we can get out of here. Is this showing or not?
But can you put it in slide mode, in presentation mode?
Sorry? Can you see this now?
We're not seeing the presentation slides.
Okay. I think you have to stop screen sharing and begin again.
Okay, let's see if this works. Is this working?
Yay!
Oh, I'm so sorry. I had no idea because I'm using a tiny screen here and then a big one in the corner. So sorry, everyone. Okay, so this was the quote that I read out. I'm just going to see, is this moving? Yeah?
Yeah.
Good. Okay, so sorry. So this is the quote that a young person said about their existence, very existence being political, and that the biggest human rights issue that they face is their right to an identity. He said, "We are born Syrian, but the occupation forces us into an identity crisis. If we refuse Israeli citizenship, we live as permanent residents with fewer rights. But if we accept it, we betray our history. It's not a fair choice." So a very brief overview of the study, and maybe if you have more questions about this, you can ask afterwards. But we know that Palestinians have used the language of human rights and leaned into international law to articulate the oppression that they experience, but we know much less about how Golani Druze living under this forgotten occupation use human rights in their struggles for justice. So this project is trying to understand a bit more about this neglected jurisdiction and this population, with a focus on how youth ages 18 to 25, how do they engage with human rights, and how is that influenced by history, their political and religious beliefs, but also the escalation of violence in the region as a whole. And we're also comparing youth's perspectives with those of older generations, those who remember annexation, those who studied in Syria, for example. And also we're comparing their views with Palestinian youth from the occupied West Bank. And this is drawing on my previous work, which I've done over the past 10 years, but also some new insights from the refugee community. And a key aim of this project is to amplify their voices from these two occupied jurisdictions. In terms of methods, hopefully the slides are moving. So it's a 3-year study, and there have been obstacles because of the current situation. And it's being conducted alongside 2 youth advisory groups. So they're involved in the research design, and they'll be involved in the analysis. And they're also advising me on how best to disseminate this research. I'm also working alongside 2 local research assistants. It's being supported by 2 NGOs, one from the Golan, one in the West Bank. So far we have met with the advisory groups. We've conducted focus groups with Golani and Palestinian youth. We've done a number of interviews, and we've got a few more to do before we'll go back to the advisory groups for the analysis phase. So today I just wanted to share some initial findings, and I'll offer some reflections on how attitudes have maybe changed since my previous research, how attitudes compare between the youth in the Golan and the West Bank, and then we'll be thinking a lot about the impact that Gaza, Swaida, and the escalation of violence in the region has had also on their perspectives. And in accordance with third world approaches to international law, I'll be foregrounding their voices, these non-elite dissenting voices through the presentation. So some young people pointed out that human rights can be invoked to help internationalize the injustices faced, to put their struggle on the map. This was slightly more prevalent among the Golani youth. For example, one young person said, human rights discussions sometimes bring attention to our struggles, but international organizations rarely take action. Awareness is important, but action is what truly matters. So there you can see this acknowledgement that human rights are flawed, but they can still be useful. Another participant suggested that human rights can be used as leverage to raise awareness, to point out hypocrisies, but also to attract funding for NGOs and civil society organizations. A participant in the West Bank did mention that human rights can be useful in highlighting their case, but many of the young people there were much more cynical, which we'll discuss later on. We'll come back to that theme. Secondly, educating children and young people about human rights was discussed as being really important, as it can remind the younger generations that their oppression is not normal and it should not be accepted. So here we have someone from the Golan who said, you know, we need to teach kids their rights early so that they can defend them. If we don't, the next generation may accept discrimination as normal. Again, you can see there's a bit more cynicism towards the role of human rights education, articulated by Palestinian participant here, who said, it's good to learn at school, but the problem is that the reality is totally different. You learn you have the right to play in school, and then you're deprived of it due to the occupation. You learn that you're equal to other human beings, but then you're treated like animals. So in the Golan, the Israeli Ministry of Education oversees the curriculum. And so Golani young people are not taught about human rights in the same way that Palestinian young people in the West Bank would be. Children in the Golan are not going to be, learners are not going to be positioned as those who are occupied and entitled to certain rights under international law. As in my previous research, Palestinian youth often drew attention to the fact that children and young people have to navigate the dissonance between the ideals they're taught about versus their lived experiences. as you can see from this other quote in blue. Another example that was used quite a lot by the Golan young people of how human rights can be used as a useful tool was when it came to defending the land, and especially they made a lot of reference to the wind farm project and the anti-wind farm mobilization. So there have been plans by an Israeli energy company to build wind turbines on Druze farmers' land. And there's been a lot of opposition to this, and there's been a legal case around this, which I don't have time to go into. But a lot of the young people cited this as a moment where domestic law, but also international law, had been really helpful in this particular struggle, and it had been quite successful. However, a lot of the young people in both jurisdictions highlighted how attempting to operationalize human rights or claim rights comes with great risks, and how these risks have really increased since 7th of October. And again, this was really pronounced in discussions in the Golan. You can see there the first quote, a young person said, "Activists are the ones who speak the loudest about human rights, but it comes with risks. Those who talk openly about occupation, discrimination, and land rights often face surveillance, arrests, or job loss. In schools, teachers sometimes talk about human rights, but carefully they focus on general topics like equality and justice, but avoid discussing occupation, discrimination, or political oppression." And another young person, there were many who said that, you know, since the war, you have to be really, really careful, or you might be detained, and a lot of talk about surveillance. So just as the title of my paper, so this quote, "just ink on paper," actually came from my previous project that I did in the West Bank with Palestinian youth, where one young person said, you know, international law would help if it was applied, but it's just ink on paper. And so we used this quote and asked young people in the focus groups whether they agreed with this idea or not. And most of the participants agreed strongly with this sentiment, especially Palestinian youth. Some said, you know, they liked the ideals of these human rights instruments, but failed to see them in their own lives. Other participants made observations that resonate strongly with concerns raised by Twale scholars. You see the second quote there, this young person really critiquing the supposed universality and neutrality of international law, and how it fails to protect those in the third world that it claims to serve. If you're considered a country of the third world, then you're not useful, so you don't exist to the rest of the world, even with the presence of human rights laws. This idea that human rights are just ink on paper meant that a lot of young people have to resort to struggle. And this wasn't something that they actually embraced. It was seen as a, you know, something they are forced to do. Yes?
I'm so sorry. We've run out of time. I'm
Okay.
very sorry, but I have to move on to the next panelist. But
okay, no problem.
Do you want to say one final word just to sum up, to conclude your presentation?
Yes, thank you. I suppose one of the things I just wanted to highlight was to go back to that question at the start, is international law dead? And I suppose for a lot of the young people, they didn't describe it as being dead, but they described it as a lie, which I didn't have a chance to go into, something that was believed in the past, but now blatantly false. And that this will have implications. The precedents that have been set in Gaza and Sweden will have implications, not only for them, but for other oppressed groups, and also for us here and the broader field of international law. Thank you.
Thank you, Erika. It's very good to have somebody joining us from Ireland today. So next is my colleague Augusto Lau from the Universidade Federal de Minas Gerais, who will be presenting on Brazil's dual role as LGBTQ+ refugees. Thank you, Augusto.
So good morning, everyone. My name is Augusto. I'm from the Universidade Federal of Minas Gerais, and I'll be here presenting two different researchers. As we were developing the discussions yesterday, I realized that the work I'm doing right now is also very connected with the researchers that are being discussed here. So I added a little bit of information in my presentation to talk about my present research. So the first research I'm going to present is about Brazil's dual role as both as a protector and a producer of LGBT plus refugees. So people are moving out of Brazil because of LGBT plus persecution, but they are also moving to Brazil from countries, especially from other countries in Latin America and Africa. And they do find their safe haven to have their identities, to live their lives. So I was very intrigued by this situation, and I wanted to understand what was happening. So me and my colleague, João Pedro, from the Autonomous University of Barcelona, we had this research going on. We received the support from a lot of people, including this this event helped me to be here today with support to travel. So is it here? Oh, I changed it. Yeah, it's not working. Yeah. So we wanted to understand the complex interactions between the attitudes and also the impacts on migrants of how the different identity and sexuality elements would play out. So we do think that migratory status and citizenship policies define and redefine mobility. They allow people to move or they block movements. And it's also central to the protection of LGBT plus people because it's, as you can see, even when people have their rights protected, as it so happens in Brazil nowadays, mobility is an important aspect of the protection of LGBT plus people. We are also looking at integration, how the individual expectations might be different from each person, but they all have in common that they are looking for a better life. And we also wanted to look how it looks from the institutional point of view, how the protection should be. So that's what we were trying to. Oops, I don't know what I changed there.
And use down to move.
Oh, down.
Yeah, up to move back.
Perfect. With that.
And then this is just point stuff. Press this to point of your own highlights.
Right. So we have an expansion of LGBT rights in Brazil, Spain, and Portugal, which are the three countries that we are analyzing in this research. But these advances are also politically challenged. So there is much going on between the legislative chamber that's mostly conservative and the judicial system that tends to offer more rights, including to migrants and other and LGBT plus people in different places. And Brazil lives a record of a lot of violence and discrimination against LGBT plus people, especially trans people. We are currently the country in the world where most trans people are victims of violence in the world, according to unofficial records, because it's really hard to have records on LGBT plus violence. And there's also a migratory system between Brazil, Portugal, and Spain that works for all kinds of migrants, refugees, but also economic migrants. So we did individual and collective conversations between 2018 and 2022, in-person and remote, where the gender and sexual orientation, how it influenced the decision to leave the country in different aspects. We also asked how they perceived and interacted with different social groups in the origin country and the reception country. So there are some shared themes with other migrants. like the migratory strategies, gender identity, violence, and relationship with migrant and local community, and also solitude and mental health. There are experiences that are shared with other national citizens in the country of reception. So the question about access to public service, the question of racism in Brazil. So people of Black and indigenous people in Brazil have a lot of difficulty to access different aspects of social life. So even Brazilian citizens have shared the same history of difficulties related to racism. But there are shared experiences with other migrants. For example, this person in the middle says, they give you a card that says you can stay here, but with that, I can't go to Brazil. It's like you are a person that's not capable to travel. You get an asylum card, but that also blocks access to many other things. So they are saying how the different migratory realities and strategies need takes you to a point where you have to make choices about your own liberty. If you want to be there in that country, you can as a refugee, but that blocks you to the possibility to visit Brazil in other opportunities. There's also this intersectionality between migration, economic migration, and patriarchy. This interviewee saying the regularization option with the high status is when you get when you get a man's help, when you get married to someone who is from the country. So that's the best option amongst the various options for regularizate your situation. It's very. It says it's. They say it's very patriarchal to do it, and it's very fast. There are shared experiences with other migrants in the sense with challenges to from contact with the other culture, discrimination, violence in the reception country. So LGBT plus people in Portugal and Spain, they also live violence, but not really related to their LGBT plus identities, but related to their migratory status and job precarity. It's also a thing that is also related to these two elements. So both refugees in Brazil that come from other countries and both Brazilians in Portugal and Spain, they describe a lot of violence in the origin country. This person, for example, is also talking about how physical security is not an issue for them as a LGBT person, which is not the rule, but they are experiencing economical violence. They can't get a job. They have insecurity about their well-being and their welfare because of the fact that they can't get a job. And also sex work is also a very common experience between both refugees that are going to Brazil and that are going to Portugal and Spain, especially trans people. There are specific themes that aren't shared with other migrants and refugees, which are related to gender and sexuality, for example. So the pathology, yes, the turning trans identity into sicknesses or diseases. This is something that they feel both when they are like trying to go out of Brazil, but also the recent changes in Spain. At some point, they added a need for a medical report to be able to access refugee as a LGBT plus person, especially trans people. And they also feel a lot of isolation connected to their gender and their sexuality. They don't have families when they were in the countries they are leaving. That's why they we have 5 minutes. Nice. But they do try. They do form a community and find a community in the countries. Also in Brazil, the thing is like violence against LGBT plus people seems to be related with the closer community. So families and the immediate community. So whenever they migrate, even if it's in the country or internationally, this seems to be a lot of help to their own security. But then it comes other questions in the way. So the discussion that we are having here are the political scenarios are very much, and that changes the how people move and where people move to. Brazil is at the same time a safe haven for LGBT people, but it's having there's a lack of support that can that people need to make them on their own. But when they moved to Portugal and Spain, they feel safe as LGBT people, but they don't feel safe anymore because they are migrants or they have a migrant immigration status that is not regular. So a prerequisite to feel safe when migrating out of to escape violence is to have a regular migratory status. So the other I will use the 2 minutes that I have, 1 minute that I have left to talk about the other project that I'm working on, which is Project Compartilha. We are teaching deliberative principles to youth and principles and behaviors. It's good because it generates communicative power. It presents procedures to guarantee that the discussions are made democratically and decisions are made in a broad and inclusive way. There's a collective rationality that we construct for conflict resolution. So it presents an option for a different type of conflict resolution. Dealing with disagreements is very important, and also fosters self-reflection about autonomy. Many youth were very impressed that also I am able to make choices my own, and I don't need to ask permissions for schools, teachers or parents and everything. So I am able to form my own opinion about different topics, different political topics. So we work on these 7 principles, which is respect, justification, inclusion, reciprocity, reflexivity, equality, and non-coercion. This is me with a group of students in Brazil. We also developed a game which is called Which Profile Is This? And we have these are 8, but we are actually now have developed 2 more behaviors that people can have in democratic, which are both positive and negative in democratic discussions. So we have, for example, someone who's motivator and tries to include everyone, but we also have someone who's too talkative and they don't let anybody speak, just like I'm doing right now. I'm overusing my time to speak too much, but I'm getting to an end. So we also, the last edition is 2 editions where fake news, as a person that disseminates fake news to talk a little bit more about this quality of information, and someone who's verifying fonts and resources. And this is the digital game we are creating from it. So this is, thank you very much for your attention. And I hope you have some time to discuss more. Thank you.
Well, I am last up, and I'm going to be giving Nadim a break from technical challenges and those. I'm a bit old-fashioned, so I'm not going to be using a PowerPoint. I'm going to be using my notes. Okay. Right. I'll try my best to get us back on track. Hopefully I can, time-wise. So my presentation is, let me remember what I called it, is human rights enforcement from below. The human right to resist in international and constitutional law. So human rights enforcement is not just limited to judicial enforcement by courts and tribunals, or quasi-judicial enforcement by similar bodies. And likewise, extrajudicial enforcement of human rights is not limited to international organizations using their sanction powers, or to multilateral military intervention by states, whether they're relying on the legally questionable doctrine of humanitarian intervention, or it's more human rights compliant, but still paternalistic successor doctrine, with which you might be familiar, the responsibility to protect. In addition, there is a modality of lawful human rights enforcement from below by people who are directly affected, even when this involves using otherwise unlawful means that would not normally qualify for protections under international human rights law that are afforded under the more limited rights to freedom of expression, freedom of association, peaceful assembly, and other democratic participation rights. That direct enforcement modality involves exercising what is called the human right to resist. So this presentation will define that legal concept and outline an analytical framework that I've developed for assessing the legal validity of claims to such a right. So, what exactly is the human right to resist as a legal concept supporting direct human rights enforcement from below? The human right to resist is an exception to the general rule of peacefulness, and indeed also to the general limitations on political rights that are considered lawful under ordinary conditions. And we don't talk about this much in the field of human rights because it makes a lot of people uncomfortable. You will not find it listed explicitly anyway in the International Covenant on Civil and Political Rights, like the cluster of general political rights that we were talking about yesterday. Its boundaries and its application do remain to be clarified. Nevertheless, it is a recognized right in around 40 domestic constitutions. That's about a quarter of the European constitutions, approximately 1/3 of the Latin American constitutions, and approximately 1/3 of the African constitutions, plus a handful of Asian constitutions as well. But it is also a right that is expressly protected under the African Charter on Human and People's Rights and the Arab Charter on Human Rights. It's also recognized elsewhere in international law in what we call general or customary international law. So this right to resist is the subject of my specialist research, and I've written a book on it, which was published by Cambridge University Press earlier this year. My university's patron saint, Thomas Aquinas, has called it the right to resist unjust rule and the duty to resist unjust law. Closer to home, John P. Humphrey, who you may know as the lawyer from New Brunswick, who developed the very first draft of the Universal Declaration of Human Rights, he called it the human right to resist tyranny and oppression. So I have developed a working definition of this right, following systematic analysis of firstly antecedent legal concepts and provisions, then existing provisions in international and constitutional law, and then finally what we call the teachings of the most highly qualified publicists as a subsidiary source of international law. So I have defined the human right to resist as follows: as the exceptional right under certain conditions to use otherwise unlawful means with a corresponding duty on others to either assist or not obstruct that resistance. So this is a right of individuals, it is a right of groups, And it is a right of peoples, whole peoples, to resist tyranny, to resist oppression, and to resist other human rights violations. But this is also a very highly qualified and a limited right. First, the resistance must be in pursuit of a lawful purpose consistent with human rights. For example, in individual or collective self-defense, for asserting the right to self-determination of peoples, for the enforcement of other fundamental human rights, or, oddly enough, in pursuit of peace, when that is pursued within what is called a human security framework. So that's the first thing. Second, this right only activates when necessity can be established, because legal remedies are either otherwise unavailable or they're just ineffective. And then thirdly, while such otherwise unlawful means may be either peaceful or forceful, they must also be proportionate, and they cannot include internationally criminal means amounting to genocide or war crimes or crimes against humanity. And the obligation that this right imposes at domestic level is to make legal allowances for immunity, for non-prosecution, and for exceptional defenses or mitigations, and then also not to extradite or exclude from refugee status those with a valid right to resist, where no internationally criminal conduct can be shown. The obligation that this imposes at international level is to either assist within the limits of the law, in other words, within the limits of the United Nations Charter, or to not obstruct those with a valid right to resist. So, in other words, this is a legal concept recognizing the idea that in some cases where no other effective remedy for violations is reasonably available, rights holders must act themselves to enforce their own human rights directly. Even though this direct enforcement right may be and is a lot less prominent now in the 21st century human rights discourse than it has been in previous eras, I argue that it nevertheless deserves greater recognition, especially in discussions about democratizing human rights, to make them more inclusive and to make them more participatory, so that the actual experience of human rights may then be more justly distributed than it is today. Indeed, I think it's failure to recognize the valid exercise of the human right to resist that actually perpetuates that unjust distribution of human rights in a manner that's prejudicial to the most vulnerable, those most vulnerable to human rights violations, because they have few, if any, other options for vindication available to them. Much like some of the case studies that have been referred to by my colleagues Omri and Erika earlier today. So the human right to resist, it has achieved a limited codification in treaty law and a limited recognition in general or customary international law. And furthermore, as a consequence of some states, the formerly colonized states that liberated themselves, and others in Europe, having adopted a constitutional right to resist in response to their own domestic experiences of oppression, whether that was by colonization or by Nazi and Soviet regimes. We have these kind of three waves of constitutional codifications: the anti-colonial codifications, the anti-fascist codifications, and then the anti-Soviet codifications in former Soviet countries. The greatest concentration, therefore, of the codifications of this direct enforcement right are actually found in constitutional law, where the right to resist is in fact recognized in approximately 1 in 5 constitutions from all regions, all the main regions of the world. So turning to international legal sources of the right, there is material evidence of implied recognitions in general and customary international law that is found in 3 main sources. The first of these is found in the 5th principle of the United Nations Declaration on Principles of International Law, or UN General Assembly Resolution 2625 of 1970, which is a well-established recognition of the right to resist forcible deprivation of the human right to external self-determination. In other words, the right to resist foreign aggression and occupation, colonization, apartheid, and other racist regimes. So that's the first source in general or customary international law. The second source is found in the third paragraph of the preamble of the Universal Declaration of Human Rights, when it's read together with Articles 21, subparagraph 3 on the will of the people, and the interpretive provisions of the Declaration at Articles 29 and 30, which proponents argue that the right to recognize the right to resist tyranny and oppression, or in other words, the right to resist forcible deprivation of the right to internal self-determination. And then the final source in general or customary international law is the seventh Nuremberg Principle, which implicitly recognizes the right and the duty to resist international criminal acts that violate peremptory, or what we call jus cogens norms, or in other words, the right and duty to resist aggression, war crimes, crimes against humanity, and genocide. In international human rights treaty law, there are only two express provisions for the right in regional treaty sources. And these are Article 20, subparagraphs 2 and 3 of the African Charter on Human and People's Rights, which codifies the right to resist colonization or other forms of oppression. And then finally, Article 2, subparagraph 4 of the Arab Charter on Human Rights, which codifies the much narrower right to resist foreign occupation. Some of these sources are more settled than others. Most of them have not yet been sufficiently judicially tested by litigation, and this work remains to be done by advocates. And therefore, in my research, I developed an analytical template for this purpose, which sets out a series of basic questions to be answered and elements to be identified in evaluating the validity of either a domestic claim or an international claim to the human right to resist within the confines of the existing law. So how can we assess which individuals and groups claiming a right to resist actually have a legally valid claim and which do not? Let's set aside for a moment the moral basis of such claims and the lex ferenda arguments about how the law should be. It is possible to assess the legal validity of claims using the main sources of existing law, recognizing the human right to resist in one form or another. The first step is to identify the positive law that may apply, as each of these vary in scope and will consequently impose different requirements. Therefore, first we ask, is there an applicable domestic constitutional provision or not? And then, is there an applicable regional human rights provision? In other words, if you're working in the inter-American or the European systems, the answer is no, probably not to regional sources, right? Although there are arguments that can be made, but we don't have time to get into that today. Then, if neither of those are there, or in any case, we ask then, is there a recognition in general or customary international law that may apply? And in particular, under the UN Declaration of Principles, also known as UN General Assembly Resolution 2625 of 1970. Finally, if none of the above, or in any case we ask, can an argument be made that it relates to an unenumerated right, an unenumerated but implied customary right, for example, under the Universal Declaration of Human Rights or the Nuremberg Principles? That's the first step. Then the second step is to assess the details of the claim against the required elements that are associated with the particular source, usually in the following sequence: as to rights holders, primary trigger violations, secondary trigger violations where applicable, in other words, necessity or exhaustion of effective remedies. Then what is the object and purpose, which, as I've said before, must be human rights compliant. Then the permissible means according to the source, including applicable limitations, as these vary from source to source. And then finally, who are the consequent duty bearers and what is the nature of the obligation? by assisting interpretation of the lex lata right to resist as a human right and as a modality of direct enforcement of human rights, this basic claims analysis framework has potential practical applications and implications for the claimants, for advocates and other practitioners, for adjudicators, and for other decision makers. And it's particularly relevant when faced with domestic level punitive measures against these direct enforcers in the form of criminal or extradition or refugee exclusion proceedings, or international level decisions arising from assistance requests, whether those assistance requests are made by states or by representatives of direct enforcers. And together with the criteria that I developed for the legal definition of the right, which I've reviewed, this claims analysis framework, I think, helps to distinguish the valid claims and also to identify the invalid claims. And indeed, this test, that an earlier variation of this test that I've developed has actually already been argued before the South African Constitutional Court by the South African Litigation Center in the case State versus Oka. And I can talk to you a little bit about that later. So in conclusion, applying the analytical framework to the Palestine case in 2025, I think demonstrates and confirms that it is actually one of the most straightforward of contemporary examples of a widely recognized example of a valid human right to resist forcible deprivation of self-determination and right to resist internationally criminal acts. And unfortunately, I don't have time to go into that. I've done that analysis. I don't have time to go into it due to our time constraints. But I think future research and applications of the human right to resist concept must also consider the more marginal classes of cases. The Palestine case is quite obvious, but there are more marginal classes of cases where the law is less clear. For example, whether and to what extent the law recognizes a human right to resist economic tyranny and oppression in the forms of plutocracy, kleptocracy. I'll be stopping in 1 minute. Thank you. Neocolonialism and other violations of economic rights, and in defense of the human right to economic self-determination. And then secondly, another class of cases, whether and to what extent the law recognizes a human right to resist in defense of the environment, whether that's by indigenous land defenders, environmental treaty enforcers, or climate disobedience. Analyzing such cases will be the subject of my future work. So in conclusion, as I think others have already said, human rights are nothing more than a nice idea if those rights cannot be enforced and thereby enjoyed on a universal basis. And yet, depending exclusively on states or on courts and tribunals, or even on international organizations to deliver human rights to the rights holders is not only impossible in certain cases, but it effectively accepts the disempowerment of those rights holders as inevitable. For these reasons, I suggest that current and future discussions of the democratization of human rights must include consideration of how we can act to strengthen, even further strengthen, recognition of the human right to resist as a form of direct human rights enforcement from below. So thank you for your indulgence. I think I've got us more or less back on time now. It's 10:15. And thank you very much to the Participatory organizers for allowing me to share those research findings with you. Please feel free to read my book. Now putting my chair back on, I'd like to open questions and comments from the floor. This is usually the most interesting part of the panels. And we have, starting back here, yes, thank you very much.
Thank you very much for the wonderful
Ernest,
presentation.
yes, okay,
My name is Daniel.
yes.
So my first question was to Omri, Erika, and Adolfi. What were the ethical issues that you took into consideration? Because they are studying very sensitive subjects. So did you, for instance, get the ethical clearance in this? Sorry. I'm saying the ethical issues that you took into consideration in doing your work. Then for Augustus, I'm trying to understand, in Brazil, is it a law that produces and also expels? Is it a law or something in practical terms? Then for Shannon, very radical, and when we started, I was thinking about it in a different way, but when you ended, I understood what you meant. But I want to find out in practical terms, how do you resist, for instance, climate injustice? Thank you.
Yeah. Can we take the first questions first to the director? Thank you, Ernest.
Ethical, because I did field work and anthropology, and this was at University of Toronto. There's considerable sort of vetting by research ethics board prior to doing anything, prior to going to field work, pilot field work. You have to try it out and see how it works. There's protocol. So there was that general framing, and also, which is sometimes kind of not actually fitting for anthropological or qualitative research. It's more, I think, oriented towards other research methods. But it did force me to really think about different scenarios and understand how I would, you know, in theory at least, and tentatively engage with certain aspects of field work. For me, it was, you know, I worked in the field before doing the research, so it was hard to kind of shift my relationship with people I was friends with or knew. So that was a constant challenge. But you know, I made sure that everyone was informed about my research and that they gave consent, either written consent or after talking to them, they would explicitly understand what I was doing, and I make sure that everyone is kept anonymous throughout and in every publication. And I shared my findings and my dissertation with NGOs, and whoever wanted to read it could. And then I got actually just one NGO send me back some comments, and I did what they asked. So yeah, ethics was really for like research ethics for issue throughout. And
Awesome.
Yes, the same for me. I mean, there are the formal aspects of it, the vetting from the Ethics Council and the informed consent. For us, since we were doing collective interviews, it was a choice that also required that the people knew that they were going to share their stories and their experiences to other people, not only to the investigators ourselves. And it, in that sense, we ended up having much more people who were already open about their experiences, like activists. So we had the opportunity to talk to those people. And I think it was very enriching to have this collective interviews, because people would complement each other's ideas, and there would be a dialogue that would feel more like a conversation than an interview. Because in the end, we just made like some triggered questions, but the interviewees started to talk to each other and ask questions to each other, and then we just let them move with the conversation further. And that was very insightful from our point of view. I think we got some really interesting aspects from this method. And regarding laws against LGBT plus people in Brazil. So formally, LGBT plus people are very much protected in Brazil. There are no discrimination laws that are in place right now. Most of the protection comes from a broader juridical interpretation of anti-discrimination and anti-violence laws. So there is no specific law saying, as an LGBT plus person, you can get married, you can be protected from discrimination, but the judicial courts understand that any type of gender discrimination or sexuality discrimination is against the more general laws. So, and one point that I didn't talk too much about because of lack of time is that the fact that we don't have laws prohibiting LGBT people to live and to live a normal life in Brazil, doesn't mean there isn't state persecution or the lack of action of state in order to protect them. And that's a problem for the recognition of refugee status when they are trying to go for other places, trying to look for that protection. Because when people describe their stories, it would very much be confused with economical decisions to move around. For example, the person who said they don't exist for their family. Once they went out of the once they were open about their gender identity, the family expelled them from their homes at a very young age. And so the person wasn't able to have a formal education, wasn't able to get was discriminated against in jobs against their gender identity. So they weren't able to have a good standard of life in Brazil, but that's exactly because of their gender identity and not because of other reasons. So it very much confuses and gets the situation very. One of the points of the research is to show we shouldn't focus or we shouldn't restrict too much to understand refugee status or protection only for people who are persecuted by state laws and policies. There are more broader social and economical processes that resemble this type of persecution.
Ernest, did you also want that question directed to Erika?
Yeah.
Yes, Erika, please.
Thank you for that question. Yeah, I suppose just by way of background, my background was in children's rights, and a lot of the research I've done in the past have been with children under the ages of 18. And there's often this tension between protection and participation. And sometimes we can be at risk of eclipsing, especially children's participation, by sort of deciding that actually how we should protect them. And I think there's a big tension there that often plays out. And I think that with my research, the current research, even though it wasn't with children, there has been that tension between, you know, sensitivities and doing this research. I mean, the project started and then a few months later, October 7 happened. And there's been a balance between making sure that voices that are being silenced and erased are being heard, and also making sure that everyone is kept safe in the way that they do that, especially when voices are under surveillance. And so what I have tried to do is very much take a lot of lead from the local research assistants, and also taking the advice from the local NGOs that I've been working with. One of the NGOs and one of the research assistants provides support, like psychological support for those experiencing trauma, including children and young people and marginalized groups. So we've been able to offer that long-term support as well for anyone who wishes to avail of that. And there have been times when the research assistant has said, look, we were meant to do interviews, you know, but we're just not going to be able to do that at this moment. It's been a mixture of, because my university didn't allow me to go travel out there, it wasn't possible for some of the time, but then I have been able to go and do some of the research when the UK Foreign Office advice changed. I think as well, because I'm at Queen's University in Belfast, there's obviously a legacy of conflict here. And so there is quite a lot of expertise in the university, and they haven't shied away from conducting research in societies affected by violent conflict. So I've been able to draw on the expertise of colleagues and the university as well, to be fair. And yeah, I think my main approach in all of this has been to really just take a lead from the advisory groups, the local research assistants and the NGOs, and like, for example, the Golan Research Advisory Group, they were very adamant that they said, look, we don't have this freedom that you have and your institution has to do this research, so make sure it counts, and we're counting on you to put the Golan on the map. So it comes with a great deal of responsibility, but there has been that sense that when voices are being silenced, and a lot of the youth in the refugee camp have also said, you know, we're isolated, we're increasingly isolated, and we want our stories told. So it's but that balance has definitely been difficult to navigate, if I'm honest, and no doubt I've got it wrong at times, but I've tried to just follow the advice of the Golan and Palestinians that I'm working with.
And I guess to shift gears a little bit, Ernest, I'll answer as best I can the question you put to me. I mean, the first important thing to clarify is that the right to resist isn't just about a right to use forceful means. It's about a right to use otherwise unlawful peaceful means or otherwise unlawful forceful means. And really, in terms of climate injustice, that's going to be the subject, sort of the human right to resist in defense of the environment, different classes of rights claimants. That's going to be my next phase of research. So I probably don't have a fully satisfactory answer for your question about how to resist climate injustice. What I can tell you about is what is going on now. I mean, primarily, as far as I understand it, there's sort of two tracks of resistance to climate change. One is the kind of peaceful civil disobedience that is undertaken largely in northern countries, particularly in the UK, but also in other places. That includes some things that we might find questionable, like throwing paint on works of art. Does that actually achieve what it's meant to achieve? I'm not sure. How effective those peaceful means are, I think we can talk about that. That's debatable. But perhaps more at the coalface, we see Indigenous land defenders all over the world using a combination of peaceful or forceful means, depending on their context and what means might be proportionate, and what, based on what other remedies might be available or not available to them. And those Indigenous land defenders really would deploy a combination of means depending on the impacts of climate change that they're facing, and who might be most immediately held responsible, whether that's private corporations or states themselves. I don't really have a better answer than that at this stage, but maybe talk to me again in two or 3 years, and I might have a more comprehensive, assertive answer for you. But thanks for the question. We've got about 10 minutes left. Is that right for discussion? About
Yes,
10 minutes?
10 minutes.
Okay, good. Yes, thank you.
So I have 2 questions and clarifications. I have 3 questions for the 3 speakers here. I'll start with Augusto. So when you're talking about community building among LGBTQI communities in their hostland, place that they're not refugees, are there demands to fit in the sense that in the intersectionality of identity, there are other categories that also matter? So their status as refugees or in terms of performativeness, not really being the same way that the host community would sort of look at. How does that play out? And that's something I would like to expand on. To Omri. Yeah. This documentation that the NGOs are doing, is it also open to the community from where the
No.
No, it's not. Oh, okay. Yeah, so that was very I shouldn't really give me wrong. Shall I say Professor Monty to be on safer side? Yeah, so I have one observation based on the question, but I really had a question in my mind. Also, I'll start with the observation and come to the question. vis-a-vis environmental resistance, it's something which, I mean, I'm speaking from Salvation experience. It's, this kind of resistance is rather comfortable and not so vilified in the sense that we have two cases. One is Narmada Bachao, which is mostly civil disobedience, long-standing movement to protect the river against construction of dams. Nothing really came out of it, but it was a very good mobilization and I mean, long drawn several decades, but also created consciousness, environmental consciousness in generations of people. So one could see that successful in that matter, but it really couldn't stop the dam from being built. And I think the state has taken it on its ego and every time you have the height of the dam that gets raised. On the other hand, you had something like Chimko movement, where women gathered and they hugged trees to protect them from being cut, and this was very successful case. So you would have some of these things that could be sort of positive, but on the other hand, from Salvation experience, you have very problematic and very difficult to speak about a situation where the resistance is against the state itself. Because you will have people fighting against the state and state oppression. And the reason is that this is post-colonial state, which is not really cut from the umbilical cord. So the legal framework is the same. And it is that gauge that continues to look down upon the citizens. So that transformation hasn't really happened. So when you resist the state against something authoritarian, neoliberal economic sense or political questions as well, then you really face the wrath of the state. So how do we fit in this complex aspect of resistance? I'm yet to read your book, so maybe the answers are already there. So yeah.
Great question, but what I'm going to do is pass on to my colleagues, and then so Omri and then Augusto.
Yeah, I kind of answered it. No, they don't have access. No, that's just that NGO, like once Palestinian witnesses give testimony, I mean, that's it, like they can't see. I mean, I assume if they ask the NGO to give them, copies, but it's not like a community or Palestinians have access to NGO materials. They would have to ask to see them. I saw I had like in the slide that had like the three kind of archival registers or scales that NGOs have. And that is like the middle scale where when someone can approach an NGO and ask to see certain materials, and then the NGO would give them access or not. But there's no like that's part of the point. There's no organized or systematic way in which Palestinian communities or Palestinian institutions have access or ability to use NGO archives at all.
If I can, so my question was based on Sri Lankan experience, where you have archived for memory creation, archives by NGOs which look at disappearance and post disappearances. Community can access, and it's also educational. So children can also look at those documents. They can add to it. They can edit it.
Yeah.
But I think the difference is who's doing it. If the community themselves have the NGO, then it's far more participatory. If it's the other, I mean the outsider, then maybe it's more governmental in that sense. That
It's bureaucratic. It's very bureaucratic.
bureaucratic.
Yeah, thank you.
I'm actually going to answer that. I have to reflect on your question and I'll answer you later. I don't have an ready answer. Don't have much time.
Okay, yeah, so thank you, great question. I'm gonna have to get those couple of environmental resistance case citations from you. That will be helpful to me in my research, so thank you very much for pointing them out to me. Yeah, India is trickier than some other countries, right? There's no constitutional provision for the right to resist in the Indian constitution. There is no regional instrument that recognizes the human right to resist, so that's two categories out. So then you proceed, and really anybody in the Indian context would therefore be, at present anyway, largely reliant on such recognitions as exist in customary international law. So you'd be looking at those three sources. Is it a right to resist external forcible deprivation of external self-determination, so from another foreign aggression, occupation, etc. If so, then it might be protected under the UN Declaration of Principles of International Law. But if not, then okay, that strikes that one out. You then be looking at, okay, well then, is it arguably a right to resist tyranny or other forms of oppression that you could make an argument that is recognized under the Universal Declaration of Human Rights? You're on a little bit shakier ground there than you are if you're looking at the right to resist forcible deprivation of the external right to self-determination. It's the firmest recognition in customary international law. Or then finally, could it be argued that resistance is is covered by the Nuremberg principles insofar as you are resisting international criminal acts, so genocide, war crimes, crimes against humanity, maybe ecocide if that ends up being recognized in the Rome Statute in the future in the way that some are campaigning for. But for now, yeah, you'd be in a tight spot in India to make those arguments effectively with legal tools, but customary international law would be your best bet. We have exactly 2 minutes left, so thank you very much, and sorry for the rushed answer. We have exactly 2 minutes left for questions, and Augusto has asked me if he could put a question to Omri. So I don't see any other hands. So if that's with your indulgence, go ahead, Augusto. Last 2 minutes.
So Omri, I'm not very familiar with McDermott's theory as me, but I am familiar with Paulo Freire's pedagogy. And for Paulo Freire, failure isn't exactly a problem, it is an opportunity to learn. So if I'm understanding you well, your argument goes around the fact that those NGOs, they produce failure, and that's helpful for the protection of human rights because like producing that failure somehow raises awareness about the issue and shows how complex and difficult the situation is. Is that where your argument is going to, or?
I don't know. I'm saying failure is failure. It's not. There are productive elements to. First of all, there's two things. McDermott is an anthropologist studying what he saw in fieldwork in schools and seeing how children in educational systems achieve failure, and he shows like how like you have a child in the class and he talks back to the teacher and he shows how that demands a lot of skill and a lot of energy, almost as much as like the teacher's pet. Where it talks about educational ideologies and philosophy, so he thinks about how to do that in a classroom, but it's not this kind of the same disciplinary or perspective as McDermott. So I understand the failure as a potentiality of failure, but it's like a different frame. NGOs do failure. That's why the McDermott framing is applicable to NGOs, because they do failure, and it's a systematic thing, and they don't have that kind of, or at least there's one example of an NGO that said, okay, let's take this failure and make it into something else that we can learn from and perceive, but that's not something that is done. And it's interesting to see if if it happens in other geopolitical contexts. I think that's a productive way to think about it.
So unfortunately, we've run out of time, and I'm sure people will continue some of these questions. Please feel free to come up and ask any of us panelists. Unfortunately, you can't come up and ask Erika at one of the breaks if you had a question that we didn't get to. But thank you very much to Erika joining us from Belfast, and to my other colleagues here in the room for keeping it as tight as possible. We had a really super tight schedule today, and we're only 1 minute over, I think, so we've got our time. So thank you so much.